issues concerning our committee and by extension the Parliament and the country of Jamaica. We ask for your guidance. We ask for journeying mercies for those who are on their way. We hope that whatever we may say or do today will be in the best interests of our country. These and other mercies we ask in your name. Amen.
Thank you. We have one apology, and that's Senator Fernell Charles. All right, so welcome again. And in front of you, or you should have gotten electronically, copy of the minutes, the summary sheet of the decisions made by the committee on all the clauses, and then there's a stakeholders comment, research findings, and final recommendation. So we'll go through the minutes. Beginning with page 1. Page 2. Page 3. Page 4. Page 5. Page 6. Page 7. Page 8. Page 9. Page 10. Page 11. Page 12.
Sorry, Chair, just a few amendments on page 12. In the first paragraph, my name, Carissa Mesada from the Attorney General's Chambers. Okay, in the fourth line, where reference was made to MAJ, I think the correct reference should be the UK court, not to MAJ. Also in the fifth line, instead of saying would take a similar approach, it should be would likely take a similar approach. So just to insert the word likely before the word take. And in the 10th line, it starts off by saying were the case, but you should insert the word not, so it should be not the case. The term damage, instead of saying should, I would prefer if you put could.
Could, okay.
Yes. That's all the amendments that I have.
All right, thank you. Page 13. Page 14. Page 15. Page 16. And finally, page 17. So I put the minutes with the amendments? So moved by Member Morrison, seconded by Member Samuda. Are there any matters arising from the minutes? Other than the examination of the general comments? Okay. All right. We will move on to an examination of the general comments from stakeholders.
Good afternoon, Chair and members. Thank you very much. The Ministry would have indicated on a previous occasion that we would have received some comments from stakeholders which, based on our assessment, appeared in the main not to be associated with very specific clauses, but we felt it important that those comments ought to have been treated with, and so we placed those comments as general comments, and we would like to take you through those comments today as well as the recommendations. And my opening comments stand notwithstanding that the very first comment appears to be linked to some clauses that you will see there. So the first comment, Chair and members, we think relates to clauses 15, 17, 20, and 47, and they were raised by the Lawyers Christian Fellowship. And in essence, the comments indicate that the new data protection regime will place obligations on nonprofit organizations who store data for purposes other than domestic purposes. The regime, LCF indicates, would require these organizations to register, pay annual dues, appoint data protection officers, and submit annual reports. And the entity recommended that the minister's powers be widened to allow for exemptions in relation to nonprofit organizations, where these organizations only process data for the purpose of establishing or maintaining membership or support for the organization or the body. The entity also went on to recommend that public sensitization efforts were required in ensuring that members of the public became more aware of the provisions of the data protection bill and the data protection regime once implemented. In response, committee chair and members, you are directed to previous discussions on these topics. First, in relation to clauses 15 and 17, the committee will recall that it made decisions in relation to these clauses already. That is, one, dealing with registration, and as I mentioned earlier, the LCF would have raised as a concern that nonprofits would be required to register, and the committee would have indicated that while registration would be mandatory for all data controllers in the initial stage, it would be at no cost, and thereafter the committee would determine the registration scheme, the commissioner, will determine the registration scheme going forward. And so the concern that would have been raised by the LCF would have been addressed by the committee previously. Additionally, clause 20, which deals with the appointment of a data protection officer, the committee would recall that based on amendments that would have been made to clause 20, that the appointment of a data protection officer is excluded for entities which are non-profits, that is, entities which are established for political, philosophical, religious, or trade union purposes. This would have been done at the last sitting when we addressed some outstanding matters where the negative list and the positive list would have been put forward, and the negative list essentially would have exempted some entities from the appointment of a data protection officer, and non-profit organizations would have fallen into that category. In relation to the concern raised that nonprofits would have been required to submit data impact assessments, recall that at some point the committee would have looked at clause 47 that deals with the need to submit a data impact assessment. And the amendment that the committee would have taken was that the commissioner would publish a notice that would specify the class or kinds of personal data or controllers that would be required to submit a data protection impact assessment. So it is our recommendation that the concerns that would have been raised by the LCF would have been addressed throughout the deliberations of the committee, and all those concerns would have been dealt with. With respect to the concern that was raised regarding public awareness, the ministry indicated, I believe, during the course of deliberations from June that we recognized that this new regime would require public education, and we have built public education campaigns and awareness schemes as a part of our implementation plan for this legislation. And that is something that, once passed, will be rolled out. So, Chair, if the committee is satisfied that we have addressed the concern, we could move on to the other concern because it requires no amendment to any of the clauses that we have already looked at. The other comment came from a member of the public, and he raised as his comment that he felt that certain words should have been included in the legislation. It was his view that words such as secure, encrypt, hardened, infrastructure, educational awareness, audit and training were critical words that he didn't find were reflected in the legislation. When we looked at it, he didn't actually indicate where he felt it was important for these words to have been placed, which clauses these words should have referred to. But it was our view that on looking at it, that words such as secure, encrypt, harden, and audit couldn't arbitrarily be placed in the legislation. I'm still on page 1. I'm looking at the general comments of Delton Phillips on page 1. Okay, it should be on the first page at the very bottom. I'm not seeing. So just below the comments of Lawyers Christian Fellowship. Not seeing them. Have you located it? Found it? Awesome. So, to repeat, Mr. Delton Phillips would have recommended in his comments that he thought some key words would have been missing from the bill. It was his view that words such as secure, encrypt, infrastructure, educational awareness, among others, were missing and ought to be included. He didn't indicate specifically where he felt that these words should have been stated. However, it was our view and our assessment on looking at the comments that these words, without indication as to where they ought to fall, were not words that we could just arbitrarily include in the legislation, number one, and that some of the words were very prescriptive and would not have been words that would be the normal approach to drafting. And so it wasn't a recommendation that we would make that these words just be arbitrarily placed in the legislation. Additionally, Mr. Phillips would have indicated that he would have wanted to see some words that would have spoken about encryption standards, essentially, in the legislation as well. He indicated that hardening of infrastructure should be addressed along with the utilization of encryption standards with reference to digital data. He also thought it was important to have minimum standards of exchange, data accessibility, and storage be defined by the Commissioner. We recognize that the data protection legislation deals with general data protection standards, and we were not of the view that technical standards related to, for example, encryption ought to be standards that should be addressed by this particular legislation. We will recall that there is already a standard that indicates, the 7th standard that indicates that you ought to ensure that you have technical measures within your organization that ensures that data is not processed in an unauthorized manner. And we felt that the clause that exists currently would address any concern that Mr. Phillips would have about dealing with infrastructure and with encryption. As such, there is no recommendation from the ministry that the recommendation from Mr. Phillips be accepted at this time. Continuing, his point would have been that he felt that the data protection regime should mandate that data controllers set aside a cash provision or to set up a data insurance scheme or to have some fixed time to provide evidence to the authority that they have satisfied credentialing or data security standards. Again, we didn't think that the legislation, one, With respect to credentialing, that such a specific requirement should be included. I have gone to the second paragraph of the analysis and recommendations. We didn't think that with respect to credentialing that a specific requirement should be included in the legislation. We also felt that in light of the dynamic nature of the field of technology, where technology standards and technology itself evolves, that we shouldn't have any specific standards stated in the legislation. Again, we draw the committee's attention to clause 30, and that deals with that's the 7th standard, which provides that appropriate technical and organizational measures should be taken to prevent data breaches. So we felt that the legislation already places an obligation on data controllers to ensure that there's adequate technical standards in place to deal with the processing of data. With respect to the scheme of insurance, it was not our recommendation that is specific.
I have a question.
Sure.
Would these be things that the Information Commissioner would be able to prescribe in industry standards, for example?
Thank you very much, Chair. That's correct. The Information Commissioner could recommend in the guidelines as well. That would be that you will recall that we moved the codes, we hardline, remove that word codes and change it to guidelines. And that would be something the Information Commissioner could recommend, as well as the particular industry could indicate that this is a standard essentially that we would want industry persons to maintain or to apply. It wouldn't be for the substantive legislation to dictate. With respect to the recommendation about a data insurance scheme, the ministry does not support this recommendation. When we did our research, we didn't find that other data protection regimes had made provision for an insurance scheme of the nature to deal with breaches. Data controllers would have dealt with the fallout from breaches on their own, and there was no special insurance scheme that would have been established in the legislation to deal with this. As such, it is not the recommendation of the ministry that a mandatory insurance scheme in the manner that is suggested by Mr. Phillips be contemplated at this time. Continuing, Chair and members, the other recommendation had to do with the recommendation that we should have a separate Health Data Act, which would be akin to other health data legislation in other jurisdictions. He cited, for example, the Health Insurance Portability and Accountability Act in the United States, and also the recommendation that the bill should make provision for persons who my apologies, should make provision for the handling of data for persons who are deceased. And then as well, he says that the bill should make reference to a provision of funds for, again, education. That tends to come up a lot, that there needs to be some sort of education campaign and awareness, and that there should be tax exemption provided to companies that engage in training and to improve the protection of data for their individual or respective companies. We'll address the matters in sequence, first dealing with the issue of a separate legislation to address health data. Presently, the bill addresses the storage and transfer of personal data and sensitive personal data, which includes health data. In our assessment at the ministry, we didn't think a separate piece of legislation that would address health data was necessary. However, we do recognize that regulations that could deal specifically with the handling of health data would need to be promulgated under this legislation. And we are aware that the Ministry of Health is currently doing its own assessment and research in relation to the appropriate regulations that could flow from this particular legislation. I would be making recommendations to the Minister with responsibility for this legislation in relation thereto. And so it's not our view that we need to have a separate health data legislation. Chair and members, you'll recall that last week in our discussion when we looked at clauses 65 and 66, the ministry indicated that the clause in the bill which deals with the avoiding terms in contracts that would require you to produce your health record, that we indicated as well that the scheme, in order for it to work, would require you to have additional legislation to support the access to health records, and that those additional pieces of legislation were currently being developed. With respect to the recommendation that the bill should address personal data for persons who are deceased, the committee will recall that in July, during its deliberation, it determined that we would accept the recommendation for the legislation to be extended to the data of persons who were deceased, and that we would adopt with the necessary modifications the provisions in the Trinidad legislation. And so we have addressed that concern. Similarly, we would have indicated earlier that there will be public education regarding the data protection regime, and so there is no need for any specific reference to that in the bill. We do not agree, however, that we need to incentivize data controllers in the manner that is recommended here, that data controllers be given a tax exemption because they provide training for their for their staff to improve their own processing of data. We didn't think that was something that needed to be included in the bill or should be contemplated in this regime. That responsibility falls from the fact that you are a data controller and you have a responsibility to process data in accordance with the legislation.
Chairman, thank you, Hadian. Just one question on proposal number 4 from Mr. Phillips that has to do with health data. And I know last week we discussed it at length, and I just wonder though if you are aware where the ministry reached, where is the ministry in terms of the regulations that they're developing, and secondly, whether those regulations, certainly part that relates to the sharing of information, could be made available to us. Because if we are going to certainly at this stage rely on them, it will be useful for us to at least have an idea and an appreciation for where their mind is, and for this committee to help in influencing the drafting of such legislation so that it gives effect to the intent and to some of the issues and the concerns that have been raised here. Though I appreciate that when those regulations will be tabled, there may be an opportunity for other consultation, but I think if at the very beginning we can at least apprise ourselves of the provision, it may be useful.
I'll answer, thank you, Chair. I will answer the second question first, that with respect to releasing the draft of the regulations or the work that is being done, that would be something that we'd have to get permission from the Ministry of Health to do. So we'd have to consult to find out if at perhaps a later stage that information could be released, perhaps while the report is being done, so members could be satisfied. But with respect to the first question, the ministry would have participated, ministry meaning the Ministry of Science, Energy and Technology, with the Ministry of Health in its consultation with stakeholders across the island. We participated in 3 consultations from Kingston to Montego Bay with different stakeholders to look at the proposed provisions of regulations that would have been dealing with health and access to health records. And so it is our understanding that those consultations were successful and that some draft documents would have been prepared in relation to what the regime would look like. As to how far advanced they are from that particular part of the process, I wouldn't be in a position to say today. If there are no other questions, I'll move to page 4 of the general comments. We received general comments from the Broadcasting Commission. The Commission recommended that the concepts of transparency and good governance should be embodied in the operation and management of the Information Commissioner. We interpreted that to mean that perhaps the Commission wanted to see those words very specifically stated in the legislation. Also, we note also in terms of comments, the Commission would have requested that all decisions made by the Commissioner be documented, published, explained, and justified. And the Commission also went on to indicate that if it is that the committee had not yet contemplated that the legislation would have extraterritorial effect, that consideration could be given to including a provision, as indicated in other legislation, to protect personal information by placing a restriction on the transfer of that personal data to foreign countries. I will start with those three. It's not our view that we need to have the words transparency and good governance hard-coded in the legislation. That is, you need to see those specific words. We believe that transparency and good governance are implicit in regulatory good practice, and therefore it need not be expressly stated in the legislation. And so we didn't think there needed to be any modification to the legislation to accommodate the concept as indicated by the Commission. We agreed that, subject to the non-disclosure provisions, that the decisions of the Information Commissioner should be documented, explained, and justified, and that particular approach is something that the Commissioner would undertake as the Commissioner carries out its work. We did not, however, agree that there needed to be a specific reference in the legislation to the publication of every decision that the Commissioner makes with respect to every data controller. We thought that to include such a provision would be onerous, because the Information Commissioner ostensibly could be making decisions in relation to many data controllers and many issues, and we didn't think that was something that we should hard code in legislation to require the Commissioner to publish every decision. What we are aware of is that in relation with respect to other regulators, that where their legislation does not require them to publish decisions, that if the decision is one that has a public interest, public concern, that has a potential to affect other stakeholders or players in that particular market, then that decision is usually published, perhaps primarily on the website, and depending on the type of reach that the regulator would like to have, it's sometimes published in the paper. And so we felt that it was that this particular regulator, or the Information Commissioner, ought to be given the same sort of leverage to determine which decisions ought to be published. Not that it wouldn't be justified, not that it wouldn't be explained to the particular data controller or otherwise documented. So it's not our recommendation, it's not the Minister's recommendation that any change be made to the legislation to accommodate the comment that would have been raised by the Commission. Additionally, the committee would recall that it would have already made a decision in relation to Clause 3, that Clause 3 would be reviewed, and that Clause 3 would replicate the provisions of Article 3 of the GDPR, which would then give the legislation extraterritorial effect. And so the concern that would have been raised by the Broadcasting Commission would have been addressed by a previous amendment made to the legislation. Finally, the Commission recommends that, given the connection between the goals of the data protection regime and modern content regulation, that the committee could consider the option of combining the functions of the Information Commissioner and the functions of the content regulator into a single agency. The Ministry looked at the recommendation, and it is not the Ministry's view that the regulatory functions of the Information Commissioner and the functions of the content regulator ought to be merged. It's our view that data protection and protection of personal information is a different sort of regime than the regulation of audiovisual content or just content, and at this time we felt that the two frameworks ought to remain separate, and that the content regulatory portion might be best served with looking at a regulator that has responsibility for information and communications technology at the appropriate time. And so it's not a recommendation that when we look at the structure of the Information Commissioner and the remit of the Commissioner, that we ought to take into consideration content regulation. The Commission, and I would believe in keeping with the concept of how we look at content and digital literacy, the Commission also recommended that if the legislation would have made provisions for administrative fines, that those administrative fines or fees could be used to support digital literacy, to ensure that the citizens would be able to understand and recognize when there is an infringement or misuse of his or her personal information. Our view is that the legislation provides at clause 4.5d for the commissioner to disseminate information about the operation of the act, and that whatever resources the commissioner has, the commissioner can use it to carry out this particular function and mandate, and that there need not be any further stipulation in legislation to specify how the commissioner should carry out its work and what resources should be used to carry out that particular function. We would have indicated that that is a function of the commissioner, and certainly the ministry will be undertaking public education and awareness campaigns to deal with this particular regime after the passage of this legislation. And so it's not recommended that any further adjustment or amendment be made to the legislation to accommodate this recommendation. I'll move now to some general comments that would have been raised by the Jamaica Bar Association. The Jamaica Bar Association would have expressed some concern that to support the data protection legislation, that there wasn't a data protection policy, and was urging the government to articulate a policy specifically related to data protection. We acknowledge that there is no single policy that is called a data protection policy currently existing in the government of Jamaica. However, we felt that the policy imperatives were clear and taken from different pieces of whether legislation or documents or treaties to which a government is a part, and also our ICT policy. And so it's our view that there exists adequate bases for our approach to data protection and the regime that we've currently put before the committee. One, we'll start with the constitutional right to privacy, which is enshrined in the Charter of Rights and Freedoms and enshrined in our Constitution. Additionally, Jamaica's commitment with the economic partnership agreement that we have with the EU and CARIFORUM states as well. Similarly, we would have had guidelines for the regulation of computerized personal data files, which would have been, which requests governments to take the guidelines into account in their legislation and their administrative regulations. That would have also guided or informed our approach. And similarly, our information and communications technology policy, which would have had as in section 3 of same, that we would have a legal and regulatory framework that would look at the protection and privacy of personal data and information. So we felt that we had sufficient policy bases to justify the data protection regime that we would have put forward, and that there was certainly at the time was no need for a single policy that would have addressed data protection. However, it is shared that the ministry is currently in the process of reviewing the information and communications technology policy to update same, and so in taking into account the comments that would have been raised by the Jamaica Bar Association, we'll be looking at expanding the provisions that relate to privacy and protection, because it will simply mirror what it is that is already stated in the various pieces of documents and the obligations that the country has in relation thereto. And so certainly that's just for information, because that wouldn't be reflected in the legislation. We move to page 6, still on comments from the Jamaica Bar Association. The bar would have recommended that the bill contemplates some new rights that would have existed elsewhere. One is a right to be forgotten, and the bar was recommending that data subjects should have the right to request deletion of personal data where there is no reason for its continued processing. The ministry would have looked at this recommendation, and it's our view that that currently, or clause 10, could address the concerns that would have been raised by the bar. As currently at present, clause 10 allows the data subject to, or gives the data subject the right to prevent or to advise a data controller to cease processing where any of the grounds listed there do not exist. So for example, if the data is incomplete or irrelevant, you can ask for the processing to cease. Also, we had recommended that where it is that the data controller had withdrawn his or her consent from processing and there was no other legal basis to continue the processing, then the data controller would have had to stop processing. And so it was our view that the present clause 10 would have addressed the concerns of the bar. Right. The other right that the bar was suggesting is one of a right for data portability, and this gives data subjects the right to obtain and reuse their personal data in ways which they choose. That would have been their interpretation of it across different services and between different companies. Data portability is a right which exists currently in the GDPR and is also found in the UK's data protection legislation, but it's also absent from a number of jurisdictions that have data protection regimes. The ministry, to be honest, doesn't have an aversion to including a right to data portability which would reflect or mirror the right which is currently in the GDPR or in the UK's data protection legislation, and it would be a matter for the committee whether or not it would want to include a right of data portability as well.
Can I ask though, Kadian, once you request your information and you get it, isn't it kind of, you can do whatever you want with it? Does it have to be in law that you can do whatever you want with it?
True, but I believe that the nature of the right in Article 20 goes a little further than that. So that particular right allows the data subject, and I'm just going to read what it states here. It's a right for the subject to receive personal data concerning him or her, which he or she has provided to the controller in a structured, commonly used, and machine-readable format, and also the right to transmit that data to another controller without any hindrance. There are usually two provisos. One, that the processing of the data was something that you gave consent to in the first place, and the processing is automated to allow for the ease of transfer. And so it goes a little bit further than just you requesting the information and taking it elsewhere. It's almost a right for you to be able to say to a data controller, please send my information to someone else as well. That is perhaps where they extend the expanse of the right.
I wondered, Ms. Smith, whether the ministry had thought about this particular provision, and if so, why was it not included? Was there a reason why it was not included?
We did, to be honest, we did. We did look at it at the time when we were making recommendations for the legislation. We felt at that particular point in time that the concept was very new, and we wanted to see how it would actually be implemented through the GDPR and in the UK before we recommended it. However, we got a number of stakeholders who would have asked us, both formally in this setting and outside, why have we not considered new rights such as data portability? We haven't seen anything adverse in relation to its implementation, and as such we are not averse either way. If the committee is minded to include it, or if the committee is minded to wait to see how it is implemented elsewhere, we wouldn't have a difficulty with either position.
All right, I put data portability to committee members to be included in the data protection bill.
Yes. Mark.
So moved.
No objection. Just to say that since it seems to be the way the most developed users of this type of legislation are going, and there's been no reason not to have it, it would seem a good idea to include it rather than leave it out.
Chairman, I share that view. I remember the example which was given by one of the persons making submissions of, say, a subsidiary of a bank and being able to pass it, and I found it almost irresistible that that should be permitted. So I'm very happy that we are revisiting it, and I support the recommendation from the bar.
Thank you very much, Chair. The bar would have also indicated that there should be a right to know when one's data has been hacked. The bill should take cognizance of growing concerns regarding cybersecurity and ensure that data subjects have the right to be informed of a personal data breach, which could lead to destruction, loss, alteration, or unauthorized disclosure. However, the ministry takes the opportunity to direct the committee to clause 21(5) of the bill to say that this particular obligation already exists. As there is an obligation on the data controller to notify the data subject without delay about any breach, security breach, and the likely effect of it, the measures that have been taken to mitigate and address the adverse effects of the breach, and also to provide name and address and relevant information of the data protection officer that the data controller has. So we felt that the concern of the bar would have been adequately addressed in clause 21 of the bill as it is. Similarly, the bar would have suggested as well that there needs to be a provision that deals with explicit consent in relation to data controllers who operate websites, that persons should be given an opportunity to consent to being a part of call or email lists before they receive information as a consequence of this type of marketing. The committee is asked to, will recall that this discussion, this was a matter that was discussed previously, and we discussed it at length. And would also recall that during the stakeholder phase, we would have received some comments from two of the larger telecommunication providers who expressed concern about how the bill is already structured in clause 11, that in their view, since it was two, in their view, already would restrict their ability to market to their existing customers with the current regime. What the bar is recommending essentially is what is considered to be an opt-in regime, where persons opt in to be a part of email lists and call lists, as opposed to an opt-out regime. Presently, we do have an opt-out regime in companion legislation in the form of the electronic legislation. Was discussed, we recommended and still maintain that we retain an opt-out regime. Additionally, it's our view that when we look at how websites are structured today, that many of the websites actually require you to opt in to receive information. So they do indicate that would you like to receive additional information, please check a box, and you have to opt in. And so we are commending to the committee that the current regime as we have it now in clause 11 provides adequate protection to consumers in relation to email and call lists. As we have it here, we call it direct marketing, and we are not recommending that we create a contrary regime or scheme in this legislation which will run contrary to the Electronic Transactions Act. And we also remind the committee of the concerns that have already been raised, that the direct marketing provisions of this legislation are already onerous, and to have an opt-in regime would be even more adverse as well. And so it is our recommendation that the legislation, there no change be made to clause 11 or any other.
I am still challenged in understanding if we are interested in protecting data, why is it that you are recommending to us that we allow telemarketing companies to take my information and push ads to me without consent, and then put the onus on me, the consumer, who are in many cases of varying abilities and competencies and capabilities to navigate these clauses, and if you wish to opt out, you need to call this number and wait 2 hours on the phone. I am wondering, why is it that you're so pressed in causing us to support such an oppressive approach by the telecommunications and other marketing companies to the consumers? Because the explanation you gave to me, I do not think rises to the level to justify not having an opt-in regime.
Okay. I'm actually in support of what Senator Morgan has said. I do believe you should give consumers the choice to determine whether they want to be bombarded with messages morning, noon, and night. What happens now is that without your knowledge or consent, and frankly, your numbers are shared with third parties right now, because any one of us who has a phone will get these pop-up advertisements from people who you have had no connection with or nothing to do with. So I support him and feel strongly that it should be the other way around. Consumers should be given the option to opt in, otherwise the data should not be shared or sent to them.
Yeah, I just wanted to ask, currently, I'm sure many people, if not all of us, would from time to time say receive marketing emails, and then you can go through an unsubscribe process if you would, and they often ask you to tell them why you want to unsubscribe and so on. Sometimes they don't require you to go that far, but is it a legal requirement currently under the law of Jamaica for a direct marketing email to offer an unsubscribe option? That's fairly straightforward. You're saying, is that in the Electronic Transaction Act?
Well, I'm going to read Section 29 of the Electronic Transactions Act. Section 29 speaks to unsolicited commercial communication. It says a person who sends unsolicited commercial communication to consumers shall give to a consumer to whom any communication is sent, 1, the opportunity to decline to receive any further such communication from that person, and, upon request by the consumer, the identifying particulars of the source from which that person obtained the consumer's contact information or other personal information. A person who fails to comply commits an offense, and no agreement is concluded where a consumer fails to respond to an unsolicited commercial communication. Last section. A person who sends an unsolicited commercial communication to a consumer who has communicated to that person that the consumer does not wish to receive any communication, any such communication, commits an offense. So as it stands right now, it is you are able to send unsolicited commercial communication to a consumer, but you must in so doing give that particular consumer the right to decline to receive any further communication. And if it is that I have indicated that and you continue to send, the legislation has stipulated what it is there. What we have in clause 11 says that an individual is entitled to, one second.
Before you go on,
Sure.
what's the penalty? You said that
It's an offense. Fair enough. I will check. I'll check. No, it's not in the section. I'm going to check. That's okay. That's okay. Yeah.
Let me just ask Gideon, does that cover, for example, the new way of capturing personal data is when you go to either a private company or in your public space, you want to use their Wi-Fi service, which is open, and in order to get the free Wi-Fi service, you have to put in your personal information. and then you get on a list, and then you're bombarded with emails from either the private company or wherever. Would the Electronic Transactions Act cover, provide it? Because in many cases, like there's a particular bank, if you go into it, you can get on their Wi-Fi, but you have to give them the information, and then they have all your information. Would it cover something like that too?
I'm going to break it down into two things, because one is there's a consent portion, because you would have consented to give them your information as a precursor to being provided a service. And usually, not usually, at times when you do that, some give you the option to indicate, do you want to receive information, and others having the fine print that by accepting the terms and conditions, you accept as a part of it that we're going to send you information as well. So that's a consent situation. So if it is that you are giving your information by consent, you consent essentially to what would happen. Additionally, from the unsolicited portion, in principle, this particular entity or any entity could send you unsolicited communication as well from the information, from the data that he or she would have. And under this regime, it would be for you to opt out and say, I don't want to get any further information from you at all.
Does that right apply whether or not you've previously consented? So, for example, if I'm rushing to and I want to access something via Wi-Fi and it's on offer and I click yes, is that some kind of a revocable consent to receive their marketing information forever, or does my right to opt out trump any prior consent?
No, you have the option to opt out thereafter. You do, because it actually it's because if it is, yes, that's correct. It would be, yeah. You would be able to.
And it speaks to commercial communications. And how is that defined? Because not all unwanted communications are trying to sell you something. You know, sometimes it's just marketing their existence and what they have to offer, or something. But it's still something you want to be able to unsubscribe from.
Thank you, SG. First, I'll go to the definition. It says commercial communication means any electronic communication which constitutes an offer for sale, hire, or exchange of goods, services, and facilities. So it tends
to be offering you something for sale, right? I mean, but why is it so constrained? I mean, why, if it's just, some kind of organization that's trying to sell a point of view, their own view of the world, whether it be religious or political or any other thing, why shouldn't they be forced to give you the ability to opt out?
Member, I think I'm pausing because this particular piece of legislation is not one that we would have done a lot of recent research on. That is one. And so to speak to why they would have restricted...
2000 and what? Was it 2005?
2006? I said 10 as well. Let me see. Just a moment. 2000? 2006.
6. Mm-hmm. Yeah. I mean, for my part, if you're relying on that provision to justify not amending the bill, that needs to be more robust in terms of giving. It can't be limited to just commercial communications. And of course, members Robinson and Senator Morgan have both indicated they think it should be an opt-in regime. I don't know how the others feel.
Can I just on the issue of fine print, I know in other jurisdictions they have tackled this, because it's one of the ways in which companies get around by having paragraphs and paragraphs which 98% of people don't read. Is 99.8% don't read. Do we have anything in the legislation which would require a company to more explicitly state the issue of, in the fine print, the issue of consent, and in terms of receiving information? Because if you put it in 12 paragraphs, nobody reads it. But if you are forced to, and I think we should force companies to do so if data is going to be shared.
I'll allow somebody else to speak.
Force them to be more prominent and more explicit about the permission to share your data, and not 2 paragraphs. Hide it in 12 paragraphs in legalese, which nobody reads and just ticks a box, and then you find out you are bombarded.
Thank you very much, Chair. I just wanted to answer, before I get to Member Robinson's question, the question that was raised by Senator Scott Motley with respect to the offences under the legislation, which is the Electronic Transactions Act. On conviction before a resident magistrate, you can be fined a sum not exceeding $1 million or imprisoned for a term not exceeding 1 year, or to both such fine and imprisonment. And before a circuit court, the fine is at large, and the term of imprisonment cannot exceed 5 years. That would have been the offence. With respect to the question about consent, the legislation does have a definition for consent as it stands now, and it requires consent to be what we call express consent, and and I think there's a more expansive definition. CPC, want to share?
It was amended, an amendment was recommended during the deliberation so that it would now cover any informed, specific, unequivocal, freely given expression of will by which a data subject agrees to the processing of that data subject's personal data. And then informed with reference to the giving of consent means that at the time in question, the data subject is informed about how the personal data will be processed, including the purpose for which the data will be used and the class of persons to whom the personal data may be transferred.
I don't know if that answers my question. It answers it in the sense that, yes, it is there. But what I really want to emphasize is, one, that they are forced to be explicit and prominent in the notification so that it is easy for a user to determine whether they want to opt in. Because right now, and I've seen it and I think it is part of the GDPR, because I've been on websites where they explicitly, you can read it easily. That's what I want us to adopt, and to force the entities to have it prominently displayed.
In response to Member Robinson's question, I just wanted to point out, though, to the committee that if we move to an opt-in regime here, it appears that we will have 2 regimes operating, though. We would have had... Okay. Right. So I'll continue. So if we accept the committee's what the committee appears to put on the table to have an opt-in regime, couldn't have this particular regime running alongside what is happening in electronic transaction legislation currently, because you'd have had 2 regimes. And so, just by way of information, this would necessarily mean that we'd be amending the approach that would be taken in the Electronic Transactions Act. That, yes, as well.
That last part, the approach would be to amend that. not rather than deal with it
That's
in this
correct.
bill. Oh. So that would be a consequential amendment as part of this act?
I'm guided by SG and the CPC that it would be a consequential amendment. Yes, a consequential amendment. I'm guided by the more technical person.
Just one question for you though. I mean, given the nature of the cyber world, a lot of these communications originate outside Jamaica and reach people here, there, and everywhere. So, in a sense, if we have an opt-in regime under our law, and other commercial actors abroad don't, they have an opt-out regime, are we putting local firms at a disadvantage relative to possibly competing economic actors abroad? Because they won't be bound by our law. They'll be operating outside of our jurisdiction. So they'll be feeding Jamaican consumers with their marketing material, which only giving you the right perhaps to opt out if their law requires them to do that. It seems to be the norm. But we would be going beyond that for our firms here. And as the whole internet marketing becomes more and more important, internet commerce, I think we have to be careful about putting Jamaican companies at a disadvantage relative to foreign companies. Yeah.
Through you, Chair, that's a consideration. And I'm also reminded that because we would have adjusted Clause 3 of this legislation to have extraterritorial effect, this legislation has that reach, but the Electronic Transactions Act, where the amendment would have to take place, would not.
So I looked at my phone while the discussions are taking place,
and you're getting all kinds of stuff, right?
just to look at the series of unsolicited promotions I have gotten. Last chance on the 25th of November. The time is now, get up to 50% off select items all week. Same company, the 27th, don't miss this incredible savings for your home, up to 50% off selective items. On the 9 a.m. on Saturday morning.
Senator, we get the point. We get the point.
No,
we get the point.
What I'm saying is,
member, we get the point.
What I'm saying is, I wasn't going to call the company's name. The texts I get from are not from overseas. They're from local companies, through local companies. And if it is that our intention with this act is to protect consumers, if the weight of protection is in the interest of the consumer more than anyone else, then I am very challenged, as I keep repeating, in understanding as a government, as public servants, our hesitance in protecting in this regard for something that is really a problem within the society.
So, which jurisdictions have an opt-in regime? Are there any examples of others that have gone that route? Yeah.
Remember, I can get back to you on that, but I know when we checked it, we had looked at a few jurisdictions, but I didn't work with that particular piece of research with me. But I can get back and I can share it with the committee coordinator, that information.
And sorry, the Clause 3 provision that is being expanded to make the legislation have extraterritorial effect. Could you just remind me or us in what way we're proposing that be done?
The recommendation was that Clause 3 would repeat or reflect what is Article 3 now of the EU GDPR, and I can share what that particular provision says, that it applies to the processing of personal data in the context of activities of an establishment of a controller or a processor in the union, regardless of whether or not the processing takes place in the union or not. And we'll be adopting similar language, that the processing establishment of a controller or processor in Jamaica, regardless of whether or not the processing takes place in Jamaica or not. And it continues, the regulation applies to the processing of personal data of data subjects who are in the union by a controller or processor not established in the union where the processing of activities are related to. And it speaks to goods or services or monitoring of behavior as far as behavior takes place in the union. So it's capturing entities that, one, are domiciled here, but also entities that are not, but the effect of what they do takes place here, or if they cover Jamaican citizens as well, if we are adopting Article 3 of the GDPR, and that's a recommendation.
And the second part of the GDPR to do with individuals applies to persons who are here, who are in the union, rather. The second limb of it that you just read.
Sure.
Yeah. Yeah. So it governs establishments in the union who may be processing abroad. But there was a second.
I want to, while you're considering, add another layer to my concern.
Are we really helping our
So, since we had the last conversation, Chair, I have done a reading on the matter and I've looked at the thinking that is taking place around the world in relation to ownership of data and how companies are manipulating data. And one of the quotes that I found from Joseph Tomain, who is a senior fellow at Indiana University Center for Applied Cybersecurity, he said, not only do opt-in mechanisms serve consumers better, they serve democracy better. They do that by helping reduce the imbalance of power between companies and individual human beings. The information that is collected about us collects our human agency and autonomy and human dignity in ways we shouldn't lose track of. The idea behind my concern is that our data is us. And as the society evolves to become more cyber focused, our data now becomes valuable. It is a commodity, just as your identity is becoming a commodity. If we're going to look prospectively at where we're going in terms of cybersecurity, then we have to really understand that remove the human element from it, our data is now a commodity. And if you're going to really give people control of their data, you have to give them ultimate control of their data, meaning no one should be allowed to use their data without their permission, which is why I support opt-in, because if you implement the regulation at the back end, then essentially you are implementing a regulation after someone has sold my data to a third-party company and they have already used it.
Chair and members, to address some of the concerns that would have been raised, I'll start first with Member Morgan. Let us go back to Clause 11 of the legislation. Clause 11, which deals with the right to prevent processing for the purposes of direct marketing. In looking at it, one of the things that we would have recognized is that it presupposes that the data controller would have received your consent already to have your personal information. So let me start off by addressing the concern that there's a third party or third person who gets your data and will be sending you information. The truth is that third person or third party should only have gotten your information with your consent. And so if you gave the data to me and I transferred it to the Office of the Parliamentary Council, for example, without your consent, then I'm processing your data in breach. And that is currently provided within the scheme of this legislation right now.
Before you finish that thought, to say a third party has my data, I am not speaking strictly about Robert Morgan, gives Juliet Cuthbert Flynn your data, but there's also a third party getting your data from a beneficial perspective. So if I'm a telecommunications company and I have your data, I can now use your data to sell on behalf of Matthew without even transferring that data to Matthew. And that is what happens within this space. So it's not a case where we're saying that X company is going to give the data, but X company is going to say to Matthew, Matthew, I have this data. You sell shoes. I can push to my persons who I have that you sell shoes. So he's the beneficiary of the use of my data, even though I never gave him permission to sell me shoes.
No, it would have given permission to be marketed too.
So this is, through you, Chair, so this is in response to the concerns. So I would have ended up where you went, essentially. So we are very clear that the transfer is not going to be allowed. But I agree with you. So you don't transfer the data, you hold the data, but what you do is that you push information on behalf of a third party. Recall that there is a limitation, a purpose limitation in the legislation where you have to indicate the purpose or purposes for which you would have been collecting my data. And the truth is, if you're collecting my data for purpose X, you shouldn't be using my data for purpose Y. And at the time when you're collecting my data, I ought to know that you're collecting my data to use for marketing for your own purposes, and I'm also collecting the data to use for marketing for any other purposes at all. I would have had to indicate that to you at the point of collection. And if it is that I'm using your data outside of the purpose which I would have told you, I'm using the data, I'm processing it contrary to what the legislation says. That's number one. And it's because of how Clause 11 is written, where Clause 11 is saying that even if it is that I collected your data and I indicated that I was going to, as in our customer-client relationship, I was going to use the data for direct marketing, you can still opt out and say to me, please do not use my data to send me any information about your company. And I believe that, I'm not defending it, I'm just saying I believe that was why the telecommunications companies had expressed the concern at the time when they came to say that they would have had a challenge with even this clause to market to their own customers. So they weren't even saying that we're going to be marketing to external or doing it on behalf of anyone else, because this clause allows their own customers to say to them, look, do not send me any more information about any promotions, any services that you have. at that point in time, don't do it, because you can opt out here. And so the legislation does, in principle, cover the concerns that you have. It's not to ensure that it's enforced. We have put those measures in place.
Finally, I think the issue I have, even as you explained it, is that, as you have said, based on the regulations that are, the clauses that are in the bill, you are now saying to them, customers have the option to opt out. What I'm suggesting to you is that, based on a diversified marketplace and diversified nature of persons within the society, many of them don't even understand what they're being asked to opt out of. My apologies. What they're being asked to opt out of. And as a marketer myself, I understand how to get people to stay in something that they never opted in the first place. So is it that after this law is passed, we start afresh, where if you want to market to me, I have to give you the permission? Or is it a case where after this law is passed, you can still market to me, and then I have to tell you that I want to opt out? If it is the latter, then it is still problematic.
In response, I think, though, before I answer that question, I believe the committee seems to be minded to want to have an opt-in regime, though. That's where I hear the committee going to have an opt-in regime. And so it would be for the committee to decide if it wants an opt-in regime. I believe, and the legislation would have to be amended to reflect that. But I believe where Member Golden would have been going would be that if we have an opt-in regime in Jamaica, what it would mean then is that Jamaican businesses would require, when they send communication external, persons would have to opt in to receive it, whereas other regimes that are not opt-in but opt-out regimes, they could send the information and require the Jamaican citizen to opt out, and so it may create a dichotomy in terms of business relations. So I just want to put that back on the table, but it's a matter for the committee, if it is that the committee is more minded to do the opt-in regime.
But when you put that on the table, even now, after the GDPR, when I seek to engage with the websites, European websites, or engage with European customers, I am forced as a website manager to give them the option. Do you want to XYZ, yes or no? It's on every time I go on a website, it asks that. Why is it that? You see, one of the things I fear about...
Is GDPR opt-in or opt-out system?
I believe it's an opt-in, and just to share, opt-in. And I'm going to check though. But why you perhaps would have seen that as well with the GDPR is because of the question that you asked me earlier, which I declined to answer because the committee hadn't made a decision on opt-in, opt-out. Because the moment the GDPR would have come into effect, entities would have had to demonstrate that they had your consent in order to use your data in a particular manner. And so every time you went on, you had to indicate, you saw the notification that said, based on the GDPR, we now require your consent, and you had to give it in order to continue. So this regime would require you to do the same thing, just as that would happen. But I'm going to check.
I was going to respond to the concern regarding a kind of unfairness for local businesses versus not a level playing field. My concern is not the interest of the corporation. My concern, as was seen in the GDPR and as was seen in Google Spain and as was seen in Safe Harbor, those cases at the European Court, is that the consumer is entitled to the protection of their data, regardless of what are the economic incentives or obligations that exist within a particular economy, right? So, you can...
That's the question. Member. A question, hold on.
We're having a wonderful discussion, so let me leave that alone. The point I'm making is that when I come to this conversation, I'm not coming to the conversation with the interest of the corporation in mind. I'm coming to the conversation recognizing the future of data and where it is going, recognizing that data is now a commodity. And I cannot associate my mind with us allowing corporations to capture the data of so many Jamaicans and then saying to them, well, if you don't want to use it, you have to tell us not to. Because that's already when the horse has gone through the gate.
But how do you begin in this new regime though when they already have your data? Wouldn't we have to make an exception?
They have to get your explicit permission to market it and to transfer it.
You see, Minister, sorry, Chairman.
They already have your information. How, if we go to an opt-in, they wouldn't be able to send us anything to say you should be able to opt in,
the
right?
regime, an opt-in regime must allow you to decide whether to opt in or not. So, I mean, if the entity that has the data has it in an opt-in regime, it must permit that person to approach you and say, do you want to opt in to us marketing to you? You know, yeah. I mean, I remember getting, when the GDPR thing came in, all sorts of people I'd never heard of were writing me and sending me stuff saying, you know, will I consent to receive stuff from them? I mean, they were forced to go through that process, you know.
Chairman,
So, yeah.
the reality is also in Jamaica, opt-in regimes protect particular groups who are more vulnerable, who as Senator Morgan would have alluded to, may have difficulties opting out. And it's not just the varying education levels that we have. We have groups of the disabled. We have those who are at the bottom end of the education level with still high levels of illiteracy amongst adults that would find it difficult to opt out. So somebody who wants you to opt into a scheme, they have to go the extra mile to ensure that those most vulnerable are protected. The other issue when you have opt-out schemes like that is that the truth is even companies, even though that's not who Senator Morgan is most concerned with protecting, companies will find that they're sold bulk promotions where they really don't know who is receiving and who isn't receiving their data because it's sold as, you know, it wasn't sold in an opt-in type situation. So your messaging persons, for instance, 28,000 Jamaicans are blind, and you don't know how many of those phone numbers are part of these mass text situations, and you're not reaching these people, so you're not even protecting the companies that would want to reach people by way of these marketing schemes.
Chairman, if the most modern major system is an opt-in system, which is the European Union's one that was introduced in the last year or so, you know, I would feel more comforted of us going that route. What I didn't want is a situation where Jamaica's kind of going it alone in an opt-in scheme. And I was mindful of the impact it might have on small firms here, you know, that are seeking to use the internet to expand and to globalize their business and find that they are constrained by our law to comply with a more onerous system of getting access to marketing vis-a-vis their competitors in other Caribbean spaces or in the Far East or wherever. So, you know, it's not just the big man versus the consumer. We're talking about all economic actors, and most of them are not big firms. They're struggling small firms. So I understand that the purpose of this is to protect consumers, but, you know, at the same time, we don't want to disadvantage our economy and our business class of all levels. So if the norm and the trend is going towards opt-in and the EU system, which seems to be the most modern major system to have been developed, is an opt-in system, yeah, I would support it.
Do you know if it is an opt-in system?
The GDPR system appears to be a default opt-in system. What I was checking, though, Chair, was the way the UK data protection legislation would have structured it. It speaks to a direct marketing code, and it speaks to the Information Commissioner putting out guidelines as to how direct marketing would take place, taking into consideration the Privacy and Electronic Communications Directive that would have been given in 2003, which appears to be an opt-out regime. So that's what we're just looking at to see how that would interact. Chair and members, I know we would want to finish this today, but I would still think we would perhaps, based on the two concerns that would have been raised, we would really want to still just to check a little bit more, just to be sure, because truth is, the regimes that exist are default opt-in regime, but they also recognize that there are opt-out provisions as well, and we just want to be very, very clear in light of the two concerns which have been raised by the members. One, about the nature of the citizenry, and also, again, not to create disadvantage essentially to businesses as a consequence of the regime that is chosen. So we just ask for a little bit more time just to look at it. All right. We'll move, Chair, to page 7. We're on page 7, and again, still looking at comments of Jamaica Bar Association. The Bar Association would have recommended that the bill should address harmonization of data protection standards and principles within CARICOM. We would just share that this legislation could not address harmonization of legislation with that of our Caribbean neighbors. In this legislation. What we can share, however, is that currently some of the jurisdictions which would have implemented data protection regimes would have used as a part of their base the HIPCAR data protection model bill, which would have been provided to Caribbean states through work done by the International Telecommunications Union. So there is some measure of harmonization there because a lot of us use the HIPCAR model bill. Jamaica being one of them, we did start with HIPCAR. Similarly, as signatories to the CARIFORUM EU Economic Partnership Agreement, Caribbean states have similar obligations to ensure that their legal and regulatory regimes provide an adequate level of protection with respect to personal data. And then finally, heads of governments have approved the establishment of a single ICT space, which includes as an activity ensuring that ICT legislation across countries are harmonized. And so we believe that with these three things in place, or international treaty obligations, the fact that we are moving to a single ICT space, and also because there exists model legislation which has been made available to all Caribbean countries, that generally speaking the legislation across the region will reflect a lot of the same principles and the same ethos. We couldn't do anything more than that in this legislation. So we feel that at the ministry that the concerns that would have been raised by the bar would have been addressed essentially through this legislation. Moving on, thank you, Chair. The bar also recommended that consideration be given to the inclusion of two new offenses. One, recklessly re-identifying individuals from anonymized or pseudonymized data, as well as altering records with an intent to prevent disclosure to a data subject following a subject access request. Members will recall that we had recently accepted, that the committee would have accepted a recommendation to criminalize the re-identification of anonymized or pseudonymized data. And that was something that was accepted, I believe, at the last sitting. With respect to the second offense, that is destruction or alteration of personal data, our research indicated that at least 3 jurisdictions would have made provision for such an offense, the offense of destroying or altering personal data. The UK's Data Protection Act at section 173 has that offense, and then similarly in Singapore it is an offense for someone to change personal data about that individual without that person's consent. And so the ministry, in looking at it, has no objection to including as an offense the destruction or alteration of records to prevent the disclosure to a data subject of information following a subject access request. So it's a matter for the committee to agree.
Okay, I put this amendment to the committee to include as a criminal offense any altering of records with an intent to prevent disclosure to a data subject following a subject access request.
Is it to prevent disclosure only, or is it to make the data different to what it would otherwise be? In other words, to doctor it, to manipulate it, to make it, yeah.
It would amount to the same. It would be that expansive. Prevent disclosure, change the nature of what the information as well, because in one legislation it actually says the person is guilty of an offense if it is that the person makes a request and the data is changed and there is prevention of access.
So moved. Yeah. Approved.
In terms of general comments, the bar also urged the committee to be cautious in seeking to over-regulate in relation to the provisions of the legislation. It was the bar's view that the implementation of provisions which would be overwhelming to regulate, difficult and costly for micro and small businesses to comply with could essentially lead to widespread and flagrant disregard of the law. With respect to the concern of overregulation, the committee would be reminded about the changes that it would have recommended throughout the course of deliberation, because we would have seen other stakeholders who would have made some suggestions along the same lines. So, for example, the committee is reminded with respect to its decision on the appointment of a DPO, for example, and how it sought to treat with that. Similarly, with respect to registration, that while everyone will register in the first instance, it would be free in the first instance, and thereafter the Information Commissioner would determine which class or classes of data controllers should continue to register. Along the same vein with the data protection impact assessment, it would be for the Information Commissioner to determine which data controllers will be required to submit on an annual basis a data protection impact assessment. So we believe that the committee, having given a very copious review of this particular legislation, would have pulled back on some of the concerns regarding overregulation and would have given to the Commissioner greater latitude to determine the data controllers who should be subjected to more stringent regulation based on the nature of the data that they're processing, or the type of controller that the data controller is.
We leave an awful lot of discretion and power in the hands of the Commissioner in terms of the design of the system, in relation to the issues that Mrs. Smith was just touching on, and I'm wondering if there shouldn't be some guidance in the bill as to the principles that should guide the Commissioner in exercising those powers and discretions, so that some broad principles for achieving a fair balance between the desirability of a fulsome register, or whatever it may be, vis-a-vis not disproportionately burdening small firms and some such thing. I'm just saying, just to leave it up to the Commissioner with nothing in the Act, as it will be, to guide how that discretion or how that power is exercised, leaves me with a little discomfort, because different commissioners may have different approaches to this issue. As we've seen in the past, when you repose great powers and discretions in individuals, how they exercise them can vary widely one from another. And those who tend to be towards the edges of balance and proportionality rather than in the middle, they do often leave a wake of effects that weren't necessarily desirable. So I think we should look at that and see whether maybe they could broadly just suggest what would be the sort of considerations that ought to guide the discretion.
May I ask a question? Do those exist in other jurisdictions?
So just to bring to attention that some of the proposed amendments that are to be made based on the recommendations would have included some guidance. For example, to clause 47, which deals with the data protection impact assessment requirements and who is required to submit the assessment. There will be listed criteria there as to guide the commissioner as to who should be required to submit the assessment. In relation to the requirement for registration, that would be a power of the minister, which would be subject to affirmative resolution and after consultation with the commissioner. And then the qualifying provision there would be, it would have to be data which is unlikely to prejudice the rights and freedoms of data subjects. In relation to clause 20, which deals with data protection officers and the requirement to appoint those, there was a recommendation to include additional provision which would specify and provide guidance as to the categories of data controllers who would be required to appoint data protection officers.
But, as regards that last point, would there be any guidance in the legislation as to how that would be triaged?
Yes, the criteria would be set out.
Yeah. All right. Yes. Well, we'll see how it ultimately gets formulated. But yes, it's definitely the right direction, I think. Yeah.
Excellent. Okay, we can move on to the next one. Page 9. The next one will be Jane Bank, right?
Jane Bank would thank you very much, Chair. The Jane Bank would have recommended again a new right of data portability, and committee members will recall that we had looked at the right to data portability and agreed that a new right with respect to data portability ought to be accepted. So I'll move now to the comments in relation to the ITIC. This deals with anonymized data processing, and the ITIC would have recommend that the committee creates balanced laws that offer decreased compliance burdens and liability protections for organizations that are using anonymized and pseudonymized data. And the ministry would have shared that with respect to the concern raised that the legislation should offer decreased compliance where anonymized data are used, the ministry is not of the view that this should be addressed in the bill. Rather, any balancing act that will take place should take place in the application of the legislation and those governing processing. And additionally, it is anticipated that the Information Commissioner will publish guidance notes, and in so doing, would balance rights of privacy versus the use of anonymized data. Thank you very much, Chair. So based on, it is our view that the legislation adequately provides the safeguards that are necessary to protect personal data, and that any considerations for anonymized and pseudonymized data are adequately provided for in the legislation already, and that there is no need for any further amendment or adjustment to the legislation to take into account this concern. I think. Accountability, ITIC also would have recommended that the legislation develop clear definitions and delineations of liability between data controllers and data processors to ensure appropriate assignment of roles and responsibilities throughout the life cycle of personal information processing. The committee's attention is drawn to Clause 30 of the legislation, and Clause 30 of the legislation that speaks to having the appropriate technical and organizational measures. This section, in addition to indicating the standards, also seeks to outline the roles of the processor, the data processor, and the responsibilities, the circumstances under which a processor is likely to be appointed, and the systems which must be in place. For example, a written contract on instructions as to how the data processor ought to operate. And it is our view, therefore, that the legislation adequately delineates the roles and responsibilities of the data controller versus the data processor, and there is no need for any further adjustment to the legislation. The U.S. Chamber of Commerce would have, I'm on page 10, would have raised as comments that publicly available data should be exempted from the scope of the legislation. Additionally, Jamaicans who make online purchases from non-Jamaican domains or websites should not be subject to this law, and that the data protection law should have a grandfather clause that sets forth that the law applies to data collected prospectively and not retroactively. In response, the ministry recognizes that while the bill does not define the term, well, it certainly doesn't use the term public data, it speaks about personal data, that the bill does address or does recognize that data which is already published or in the public domain is data which will not fall within the regime. And so if we look to clauses 23 and clauses 24 of the bill, it says that the conditions in outlining what qualifies as fair and lawful processing, the bill indicates that data which a data subject has published is, if that type of data is actually processed, then that the processing is considered to be done lawfully and fairly, or lawfully, I should say, in the circumstances. It's similarly repeated at clause 24(1)(e), and also in looking at clause 68 of the legislation, or of the bill, my apologies, clause 68 of the bill, which makes provision for the confidentiality of information. It states that that disclosures which are made for the purpose of discharging functions under the Access to Information Act, under this Act, or in accordance with treaty obligations are not considered to be breaches of confidentiality. And so we believe that where it is that the data is publicly available or could be made available under other legislation, then this data is not covered by the legislation, and so this concept of public data is already appropriately covered. The committee would have noted its recommendation in relation to extraterritoriality, and so certainly the recommendation that that purchases from non-Jamaican domains or websites not being subject to this law could not be accepted alongside the amendment to clause 3 to extend the reach of the legislation.
But just to understand what we're saying in terms of extraterritoriality. So if I go onto Amazon to make a purchase of something using a credit card, is that a transaction that our Act will apply to?
you're purchasing from an overseas website. Yes, well, if you're supplying your information to a person overseas, that person would then become a data controller by virtue of the definition that we have here, because the person is processing personal data of a subject who is in Jamaica. Right. Right.
That's under clause 3 as it is already?
Well, as amended. We had
as amended.
Yes, the recommendation was to amend it to speak to a data controller who, though not established in Jamaica, processes personal data of a data subject who is in Jamaica, and the processing is related to the offering of goods or services to data subjects in Jamaica, irrespective of whether payment is required, or relates to the monitoring of behavior of data subjects as far as their behavior takes place within Jamaica, which is similar to the GDPR provision.
And so the language in the middle of that speaks to offering goods or services to a data subject, or whatever the language was, in Jamaica, that would be deemed to, or that would be considered to include a situation where I go on to Amazon.com to buy something. I mean, in other words, the fact that it's open to anyone who can access the site and has a credit card to shop on it, it would be sufficient, you think, to bring it within that as being they're offering it to me.
Yes, because it says irrespective of whether payment is required. Once there's an offering of goods or services, it would then apply.
What are the consequences of those persons misusing the data overseas?
If them come here, you can arrest them, Frank.
If them come here. That is the question. If them come.
I guess you could seek mutual legal assistance, theoretically. I mean, if they committed a serious offense under this act, is it a situation where it might be where you could seek extradition or mutual legal assistance to support extradition? No, I mean, in practice, isn't that the answer really, that you've created it? The law here makes what they have done a criminal offense in Jamaica, even though they're not here. So if you wish to pursue it, if Jamaica wished to pursue it, Jamaica could attempt to pursue it through that mechanism if there was an extradition treaty with where they were, and if it was an extraditable offense and all the other hurdles. But in theory, that would be one way in which you could enforce it.
But why we put it in the act if we can't enforce it?
Thank you. If Amazon misuses your data, how are you going to enforce it?
Yes.
Or are you going to just send two bad men out there? No, well, but
Chair, we could, in response as well, we would draw the members' attention to Clause 62. Clause 62 does provide an opportunity for international cooperation for the Minister, after consultation with the Minister with responsibility for foreign affairs, to make regulations as to cooperation by the Commissioner with authorities in foreign states exercising similar functions to those of the Commissioner under this Act. And it will be in a similar kind of assistance in terms of whether or not we'd be able to get some sort of opportunity to, to exercise some sort of
civil remedies.
Civil.
Are there civil remedies? In other words, remind me, the bill, does it create civil causes of action for data subjects to bring proceedings for breaches of the statute against the offending parties, as well as creating criminal offenses? So could, for example, if I went on a website that was managed in another jurisdiction, and I couldn't persuade the powers that be in Jamaica to attempt to criminally enforce those provisions abroad for whatever reason, could I bring proceedings and seek to serve them abroad? In other words, would I at least have a right under Jamaican law that I could try and enforce abroad?
Well, Clause 71 now allows an individual who suffers damage or distress by reason of any contravention by a data controller to seek compensation from the data controller for that damage. So Clause 71 speaks to the circumstances for damage and then the circumstances for distress. So you could use the Clause 71 approach to try to get compensation and serve overseas, on the company.
But could you get anything out of it overseas
in America
without you have prior
I think so.
signatory
I think so.
by
You'd
the
have to prove that
by the states?
Suffered some, I mean, tort law is normally territorial too, In other words, you have to commit the tort in the jurisdiction where you're sued.
We do have treaties now
But
that
in the case of defamation,
we can enforce under some criminal
pretty sure you can.
issues,
If
but I don't know.
newspaper defamed you, you could sue them. You don't have to be an American citizen or a resident in America to sue.
Can we hear your comment, SG?
We were just discussing, Chair and members, just the ability to member with us question to the ability to enforce, to bring an action. Enforcement is not even an issue for us. To bring an action essentially in our local courts on the civil side where the entity is domiciled, incorporated overseas. And I think we... Yes. Sorry about that, Chair. So we were discussing the possibility of how we use our Clause 71 to be able to bring civil action. And I think we are agreed that you'll be able to bring civil action in our courts. Now, the issue of getting them to answer in this jurisdiction and service is perhaps where you would have to engage. Well, in the absence of any treaty provisions that allow for that, you'd have to engage the legal system of that particular country to be able to serve the documents essentially on the overseas company and the overseas entity to allow them to answer in court here. But I think the larger question, the question you would have asked first is why would we have included a provision like this, which is and a provision meaning the amendment to Clause 3, where there's some difficulty with enforcement. I believe that the committee at the time of consideration wanted to ensure that it was wide enough to cover all circumstances and the possibility may exist now and in the future that you could be able to enforce actions in an extraterritorial manner, and wanted to make provision for that as well.
But wouldn't
and
it also be a good idea?
As well,
wouldn't it be a good idea to look at the CPR, the Civil Procedure Rules, and the rules that govern service outside of the jurisdiction to see whether, for example, we ought to in here create any kind of specific right to serve outside if the breach has occurred outside Jamaica and the person isn't present here and doesn't have any business here. I mean, I don't know what the CPR, how liberal it is on those issues, but given that we're dealing in an area of life which is intrinsically cross-border, so you need to kind of face that frontally and create as give the person the best possible chance of being able to vindicate their right.
I mean, we can check the exact provision. CPR does allow for service out of the jurisdiction. But in terms of, you see, it's more than just service. How do you actually get them here? How would you enforce a judgment after? So for instance, in terms of family matters, we actually have a law, reciprocal enforcement of judgment. So we have to pass a law to allow for that. But that is also treaty-based. But it's not usually enough just to have the treaty. You have to then have implementing legislation. So that was a treaty-based implemented legislation in terms of enforcement of judgments.
We have a piece of legislation for the reciprocal enforcement of judgments, but it has to be backed up by there being a treaty with a particular jurisdiction. We have, like we have with certain places, and there are many that we don't have. But at least then, if you have the legal regime here creating the cause of action and the ability to serve it abroad, you could get a default judgment here if they don't enter an appearance. If you've effectively served it, then enforcement now, you'd have to sue on that judgment abroad. If there's no treaty system to allow you just to register it abroad, you'd have to enforce it like a new claim, but at least you would have some grounds on which to proceed if you really felt seriously committed to it, Because the reciprocal enforcement of judgments typically would allow somebody who gets a judgment, say in state X, against a person here, they can just register it in our Supreme Court and enforce it. If you don't have that, then you have to sue on it as here and get a judgment here on the judgment that you got abroad. But that is a possible procedure that our people could follow if there is no treaty system in place to allow the locally obtained judgment to be registered abroad.
Kadian, can you summarize that? What would be the recommendation?
Chair, I believe in relation to this matter that I think what we're being asked to do is to check whether or not the CPR and the provisions in the civil procedure rules that deal with service for civil matters of documents outside of the jurisdiction would adequately allow for at least service of proceedings, of civil proceedings consequent on Clause 71. And if not, I believe the member is suggesting that we look at how it is that we can ensure that at least we provide that level of protection for the service of the documents out of the jurisdiction. And then, my words on this, I hope I have captured the member's thoughts correctly. Enforcement of judgment will have to come based on other treaty provisions, which perhaps Clause 62 would be the place that we'd look to have those type of arrangements. So that requires us to do a little bit more research on what the CPR currently says.
Mrs. Newton, forgive me, and I know the days far spent and we need to go, but I have to go back to public data. And I hear what you're saying, and I did refresh my mind on the provisions in the clauses identified. But I can't understand what would be the challenge in just having a definition for the term public data. And I say that because it just makes it easier for persons who take up the law and want to read it to know where to find something. Yeah? So I'm putting it for your consideration.
Is it that we would perhaps be saying that this bill does not apply to public data? That would be the context, because what the chamber was suggesting was that we should specifically exempt it to say that this particular bill doesn't apply to public data, and then we define what public data is. But I believe that given how we have defined what personal data is, we wouldn't need to. But let me consult with the drafters on this.
You could consult with them and hear what they say.
But wouldn't you say that public data is quite wide and we're really dealing with personal data in this act?
Agreed. The legislation is, we agree, dealing with personal data. usually a definition is provided where the term is used. And because of the nature of and the scheme that we have used in this legislation is to identify essentially what are the types, what type or types of data that is being covered or that are being covered by this particular legislation. So we are covering personal data, we've defined it, and insensitive personal. Because of how we have defined it, anything else that doesn't fall within that remit, we have said we're not dealing within this legislation. And what we have specifically done actually is to take it one step further to say that in relation to data falling within this category, that is, if you have made the data publicly available, then you cannot claim a right under this legislation where you have made this data public already. So you have made this data public. So you can't claim the rights which are afforded in this legislation if you have done so. So I think it's how we have structured the scheme of the legislation that to invite a new term called public data, we'd be changing the approach or the way that we have structured the legislation to try to include this term called public data, which we haven't used, which we wouldn't be using, to say that public data is exempt.
When I accept, sorry, that you reference that it is an exemption under 23, so you can claim confidentiality where the information is already in the public domain. So you don't use a word. You have not used the word public data, but you have used similar words like information that's already in the public domain. So I'm saying for ease, for the person who doesn't have the kind of training like some others, that may be useful to just have a definition that tells what that information is.
And point through you, Chair, I take the point, but I just want to make sure that because the word public domain was my word, I wanted to make sure I'm clear. The way right, it was published, right. So the way the legislation has structured it says the data subject has published the data. So it's still maintaining the consistency of the language throughout the scheme, that the data which we are talking about, and I believe the word data now will be changed to personal data based on the amendment that we would have made. And the scheme is to say that if it is that is that the data subject, him or herself, would have made his or her personal data public already. So it's not quite talking about public domain where you could have a set term that maybe would have been capable of definition in the true sense of the word. And in 24(1)(e), where it is used again, the information contained in the personal data has been made public. So it would be very difficult perhaps to, well, in my view, no. I wouldn't recommend it. It would really change the nature of how the bill is currently structured. Just to complete the comments from the U.S. Chamber of Commerce, so we would, Chair and committee would recall that we would have gone where we went because of the recommendation of the Chamber that in relation to purchases made by Jamaicans on non-Jamaican websites, and so we're going to revisit that matter because it affects the implementation of the amendment to clause 3. The retroactive effect of the legislation, the ministry is not recommending that. It's our view that a bill or legislation only has retroactive effect if it specifically states so, and there is no provision in this bill for it to have retroactive effect, and so it's not going to only apply to data which is collected from the date of passage onwards. It will apply to data which you already have in your possession at this time, which goes to Member Morgan's concern about how you deal with that data.
Please explain something to me. You're saying that the bill is not intended to be retroactive. No, it's not. I'm seeking clarification. That's what you're saying?
No, it's not going to be retroactive.
Okay.
No. With respect to the Media Association of Jamaica, I know we said that it didn't necessarily relate to a clause, but the concern relates to clause 6, subsection 6. My apologies. It's their view that this section breaches the rule of natural justice and that a person be heard before a decision is made. They have highlighted a number of sections which they feel, or which it feels, breaches this rule. Section 6, subsection 6, 10.5, 11.3, 12.5, and 13.5. And it's of the view that the legislation should give a data controller a right to be heard or a right to make representation prior to any determination being made by the Information Commissioner. In light of this, the Media Association recommends at clause 13, subclause 7, that some amendments be made, and the amendments that they're recommending at 7, well, on new 7, is that notwithstanding the rights and various relief provided to data subjects in Part 2, where an application is made by any data subject to a commissioner for relief against any data controller, the data controller shall be given an opportunity to be heard on the application before the commissioner arrives at a determination. The ministry is of the view that the absence of a specific reference to the data controller's right to be heard anywhere in the bill does not mean that the provisions in question are in breach of the data controller's rights. The right to be heard is implied in the rule of law. The Information Commissioner could only satisfy him or herself if he or she engages a data controller on the complaint which has been made by the data subject, and a specific reference to the right to be heard is therefore not necessary. The committee, the ministry has, however, left the matter open to indicate that if the committee is minded that we specifically include such a statement, that such a statement be appropriately placed in the legislation.
Because there is a right to appeal already set out in the bill, so that is the right to be heard essentially.
But it would happen after the judgment, all right? Or the decision?
No, but each of these provisions that they refer to is it relates to a direction that the commissioner is giving the data controller. So if the data controller has an issue with it, the data controller can appeal. I think we had already discussed in relation to the appeals the whole question of staying the decision, right?
So you're not recommending adoption of this language then, right?
We have. They do. Chair, we will defer to CPC. We didn't have, as indicated, we didn't think it was a necessary inclusion. We didn't think so, so we are fine with it not being, with no amendment being made.
Okay, I put to the committee members that there would be no change here in these sections. No objections, so moved. Please continue, Ms. Smith.
The Chair and members, you'll recall that the FID would have raised some concerns in relation, general concerns about the applicability of the bill to its operations. We would have placed their comments here on the general comments because it basically covered everything from the subject access rights straight to clause 31. The FID indicates that many of the requirements listed in these sections will prove problematic, as the Act itself recognizes that some requirements will be prejudicial to the functions of certain data controllers and provides for certain exemptions. So basically they were saying that their operations ought to be exempt from the legislation because of the nature of how it operates and what it does. The FID in its submission, in response, the ministry notes that the FID in its submissions would have acknowledged that under the legislation, it is a data controller and subject to the requirements and standards imposed on controllers under various clauses. It lists them there, 6, 10, 13, 15, and goes all the way to 47, 48, 9, 59, and 67. In this regard, the FID averred that the investigative nature and function of the entity meant that many of the requirements in these clauses could prove problematic, and determined that the exemptions that would have been provided at clauses 34, 35, and 36 would not suffice to assist. And just by way of recollection, clauses 33, 4, and 6 deal with the exemption for national security, law enforcement, taxation, and statutory functions, or regulatory activity. In response, the ministry, in response, reminds the committee of the following. One, in relation to clause 33, which deals with the certificate, the exemption certificate from the Minister of National Security. With respect to the comments of the FID, we note the same, we meaning the ministry. However, it is anticipated that in matters which are highly sensitive, such as those which are dealt with by the FID, the court will treat with the information and the proceedings in such a manner as to protect the integrity of the process. And so, I don't know if members will recall that the FID would have explained that the sensitivity of some of the matters that it dealt with, that even to get a certificate from the Minister of National Security and to have that certificate being open to a process of appeal before the court could allow for sensitive information to be revealed that it wouldn't want to have made known. And we are saying that we believe that the nature of the court system and the court process, that the integrity of the sensitive information that the FID would treat with would be appropriately dealt with by our courts in knowing the situation with which it is faced. And so we felt that the national security exemption and the certificate that could be provided is one that would be able to provide the FID with adequate protection. We also refer to clauses 34.1 and clauses 34.1 to 3, which speaks about exemptions for law enforcement, taxation, statutory functions. And we say, as it relates to the FID's concern, as it relates to the FID's concern in clauses 34.1 to 3, which regards the application of the exemption where the first data protection standard and clause 6 is likely to cause prejudice. The determination of likely, and I'm going on to say these are the determination of likely prejudice. It is the ministry's view that it is the data controller that is the one who will make the determination as to whether or not there is likely prejudice to the performance of its functions, and where aggrieved, the data subject can appeal to the commissioner under the appropriate clauses. The committee is reminded that the purpose of the Data Protection Bill is to protect the rights of data subjects. Consequently, exemptions to those rights should only be provided to the extent that they are deemed necessary. We're not recommended blanket exemptions for entities. I'm on page 13. And then with respect to clause 36, which deals with exemptions based on regulatory activities, we are of the view that the exemptions provided by clause 36 for regulatory activities would adequately cover the operations of the FID. And so, Chair and members, if you will recall, during the course of discussion, the FID would have requested that some specific carve-out be provided for its operations, as it didn't feel that the clauses and the current exemptions or the current safeguards, would have adequately provided a protection for its operations. And the ministry maintains that in relation to clauses 34, with the certificate of exemption from the Minister of National Security, clause 33, clause 34, which deals with exemptions for statutory functions, and then clause 36, which deals with exemptions based on regulatory activity, that the operations of the FID are appropriately addressed. And so we don't recommend any further changes to the bill.
So if the FID is investigating an allegation of corruption within a ministry, like the Ministry of National Security, say, they would have to go and rely on an exemption from the National Security Ministry. The FID is really at the center of financial crime investigation. So having necessary for them to rely on third parties to exempt them in some way from disclosure requirements, I think we have to be very careful about that.
But that operates now with the ATI Act. Right now, under the ATI Act, if somebody went to the FID, there's no automatic exemption for them right now. They would have to rely on the exemptions. Oh, you're saying though that they don't have to, but right now they could rely on a minister's certificate right now under the ATI Act, but they could, it's true that they could also assert exemptions themselves, which is again sort of to me the scheme under the Data Protection Act that deals with these national security exemptions outside of the certificate. So it's a similar sort of regime.
Sorry, you raised the ATI Act in relation to, like, if somebody wanted to make an ATI request of the FID? Yeah. All right, well, okay, that's one thing. But if the FID is investigating someone and is hacking data or doing something that's pursuant to that investigation, or is somehow accessing personal data,
what they would have to do then is claim an exemption, which would be allowed again under the same data protection, the same kind of national security exemption.
But is the exemption premised on a certificate being issued by a third party, or it's an automatic thing? That is, that once they can claim that they're acting in furtherance of their investigatory functions, they don't need to have a third party's certification in order to claim that. That's all I'm asking.
It's two different things. So there is the certificate of exemption that can be issued by it would be the relevant minister. But outside of that, there are exemptions that are inbuilt in the Act as well, which do not rely on the certificate being issued.
So apparently they just didn't read that then. They were...
I think it really clear though that the exemption is by default?
Look at clause 33
like,
for instance.
You don't need the intervention of a minister.
Look at clause 33 for instance.
Yeah, you don't need the exemption
which is,
of a minister.
I mean, and that's the minister of, sorry, but 34, it relates to law enforcement. So 33 is the minister, and then 34 are agencies. But then they have two options, so they could actually do it themselves, or they could go through the minister responsible for national security.
Why don't we use the word investigation in there at all? Preventing is one thing. I mean, investigating, if you investigate, the crime may have occurred already, you know.
But Kadia, wasn't there consultation with the FID?
Investigating is more than detecting. Investigation is the heart of what they do, so I don't know why we don't say it.
Chair, it's I don't like to say it's a matter for the committee, but we wouldn't have, a challenge with adding the word investigation if it is that it provides greater clarity, that it is covered, so there wouldn't be a need. I believe. Detection, you could add it. Okay, all right, so to that clause, so it would be to clause 34. Investigation. So the order. So it would be Judith. So it would be the personal data process for the purposes of the prevention, investigation, and detection of crime. Would that work? I'll work it out.
Prevention, detection, investigation, I think, is a logical sequence. But again, only logical to me, perhaps.
All right, I put it to members to add the word investigation in clause 34, subject to 34(1)(a). Yeah. No? Other places?
And other places that would be fall.
34(4).
Yes. Wherever it's required. Right.
Okay, I put it to members to add the word investigation wherever it is necessary in the bill.
When used with prevention or detection of crime.
When used with prevention or detection of crime.
Yes.
If there are no objections, we'll accept that amendment.
All right, thank you very much. Chair, I'm going to ask that since we have to come back on some matters, that we're going to come back on the recommendation from the Office of the DPP. That particular recommendation, I kind of share with members, but we wanted an opportunity to just look back at it. The DPP would have been recommending, or the office would have been recommending, that the committee gives consideration to having an exemption for the purpose of law enforcement matters, similar to what currently exists in the UK data protection legislation. And just to share, the UK legislation has a specific part that deals with law enforcement processing, which in principle would also cover some activities of the FID, of the police, and of the prosecution. It's a very elaborate section. We have looked at it. We have formed the view that the exemptions currently in the legislation adequately protect prosecutorial activities. However, we would just want an opportunity to come back to the committee to present that information to the committee as we have looked at it. So we're not recommending a change, but we wanted to at least put the different positions to the committee so the committee could understand why we are not recommending any change to the scheme that we currently have in the legislation now. With respect to the Press Association of Jamaica, members will recall that the Press Association of Jamaica would have indicated that there should be a blanket exemption from the provisions of the legislation for the practice of journalism. It felt that this would be a tidier approach rather than the amendments that exist in the bill, and that it felt that the Defamation Act already provided an adequate framework to protect data subjects in relation to the use of their data. Our research reveals that no jurisdiction gives a blanket exemption to journalism, even in the presence of other legislation that protect the rights of data subjects. For example, legislation that deals with defamation. The ministry is of the view that the exemptions for journalism currently provided in the bill are adequate, and a blanket exemption contradicts the purpose of the legislation, which is to protect the data of all citizens. We draw the committee's attention to the fact that the legislation aims to be to adequately measure up to similar laws in other jurisdictions, and the absence, and if we include a blanket exemption for journalism, we would be creating a regime which runs counter to what we have seen elsewhere. And so it's not a recommendation essentially that we make any adjustment to give a blanket exemption to journalists. from the provisions of the legislation. And then finally, we got a comment from another stakeholder which says that there should be open access to data such as public and private records, and there should be a caveat in the law which allows citizens to have their data freely accessible to all. The ministry didn't agree with this recommendation, and we felt that this recommendation would have run counter to the ethos of what we're seeking to do, to have open access to private records, to open access to data to the extent that the data contain personal or sensitive personal data. Where it is a public record, there is an access to information regime, and so there already exist provisions in the law to deal with access to public records. To the extent that citizens should have their data freely accessible to all, you can by consent already give your data to whoever you choose, and so there is no need for the regime to do anything further than it has done already. And so there's no recommendation from the ministry as to any change consequent on this particular stakeholder comment. Okay, thank you very much, Chair.
All right, thank you, Mrs. Smith. All right, so there are 3 items for further research. One has to do with the opt-in, opt-out regime. The other one has to do with the DPP. And then the other one, the third one would be with regards to whether or not you can bring action against an international company. Okay, so those are the 3 items to be researched and to come back to the next sitting, which would be next Wednesday, December 13th? December 11th. Next Wednesday, December 11th at 2 p.m. I'd like to make it the last week, yes. All right, is there any other business? Or if not, the meeting stands adjourned. Thank you.